meeting. I'll start out by reading the Ethics Act statement. It is your duty to avoid conflicts of interest and appearances of conflicts of interest in performing your duties as a member of the Authorized Practice Committee and North Carolina State Bar. Is any member of the committee aware of any personal conflicts or appearances thereof with respect to the matters before this committee today?
No.
Chairman, this is Matt Smith. I need to recuse myself on number 19, Mr. Joseph Irving.
I have no idea why, Matt.
Okay. That is,
I don't want to get sued, David.
Brian, are you managing the waiting room still? Looks like there are a couple people there.
I am.
Oh, never mind. I know why they're there. Never mind. My bad. In fact, that's actually a pretty good segue to myself. So logistically, what we'll do today, we'll start out with the prepaid legal plans. We'll then go to the full discussion items. We have two visitors with us today, Ms. Alexander, which is one of the items on for full discussion, and Ms. Rubin, who is part of the consent agenda. And so they will be they are in the waiting room and they will remain there until their cases come up. So those are the two people I'm assuming that I'm seeing in the waiting room. And then there are a number of matters that we will pull from the consent agenda, and I'll give folks an opportunity to pull others if you so choose when we get there. So why don't we start out with the report on the prepaid legal plans, and Savannah.
Thanks, Kevin. So this past quarter, we had one prepaid legal services plan file up for registration. Since writing my report, I've considered that plan and it was denied registration. 22 plans submitted amendments requesting to add new participating attorneys to their plans. All of those amendments were reviewed and accepted. And then we have one action item for today. Last quarter, we discussed one plan that did not file its annual registration report and pay the annual registration renewal fee, which is grounds for the registration of that plan to be revoked. The plan instructed me to go ahead to try and issue a notice to show cause to the executor of the plan owner's estate because that plan owner died unexpectedly. The purpose for doing that was to try and figure out if this plan was still being operated by someone else, whether it be his child or whether he sold it to someone who is still operating that plan. We went through trying to figure out who the executor was, spoke with the attorney for his estate, and are confident now that no one is operating this plan anymore. And I've spoken with the only participating attorney and who's indicated in the file about whether he believes that this plan is still operating, and he does not. So it's my recommendation that this committee request that the council enter an order revoking the registration of the plan, and I'll serve that order on the executor of the estate.
Okay. Any questions or comments for Savannah? And the chair would entertain a motion that we recommend, or that we request that the council enter an order revoking the registration of the plan. Is there a motion?
Matt, so moved.
Is there a second?
Second the motion.
Any further discussion? All those in favor, please vote by clicking on your participants tab at the bottom and clicking the green yes or the red no.
Kevin, I believe that passes unanimous.
All right, it passes unanimously. Thank you. Let's move on to the full discussion agenda. I am going to take these matters out of order just in respect to, since Ms. Alexander is with us, so she doesn't have to wait any longer than necessary. So the first matter I am going to call is number 3, Tammy Alexander. And Brian, if you would let Ms. Alexander into the group discussion from the waiting room.
All right, I'm doing that right now.
Ms. Alexander, can you hear us? Is she muted, Brian?
No, I see her camera is on, but she's not connected to audio.
Ms. Alexander, can you connect to audio, please?
I'm going to send her a chat, David.
Okay.
Here she comes, it looks like.
Yes. All right, Ms. Alexander, can you hear us?
I think she needs to unmute herself.
Yes, sir.
All right, Miss Alexander, welcome. My name is Kevin Williams, and I have the privilege of chairing the Authorized Practice Committee of the North Carolina State Bar, and we're at the point in the agenda where your matter has come up for consideration. So
Wow.
logistically, what I'm going to do is turn this matter over to staff counsel for an explanation of the case, and then we'll give you an opportunity to briefly respond, okay?
Okay.
All right, thanks for being with us today.
Thank you.
So Ms. Alexander is a paralegal, and to the best of my knowledge, she's not employed by any lawyer. In late last year, she wrote to a prisoner who was already represented by counsel in prison and told him that she had been given his case to review for a new trial. The prisoner's wife responded to Ms. Alexander and told her that he was represented and he did not need her services. Nevertheless, Ms. Alexander wrote her a second and third time. And then in March, she sent a letter to Judge Futrell asking for the expungement of the record on behalf of an inmate. And she identified herself as an attorney on that form. I'm going to share the screen briefly, my screen briefly for a second. I don't want to do this on a regular basis because it kind of disrupts the gallery view. But this is the copy of the petition in order of expungement where she signed where it says name and address of petitioner's attorney. So after that, she wrote a second letter to the judge in which she again advocated on behalf of this particular prisoner and talked about the merits of the case. All of this was ex parte. And then we later learned of yet a third letter that she wrote to another Superior Court judge, Judge Bragg in Monroe, advocating on behalf of yet another prisoner in another case. So that's essentially the facts of where we stand.
Okay.
Can I ask a question?
Hang on one second. I'm trying to find you on my screen, Miss Alexander. Was that you who said that?
That was me who said that.
Okay. Yep, I can't find you, but in any event, the floor is now yours to ask questions or to respond as you deem appropriate.
Okay. I just want to know who the first one was because I think I forgot who the first one was. If somebody can answer that, Mr. Johnson can answer that.
To the
Who the first client was?
The first
Yes.
the person you attempted to, you sent
Yes.
the letter to? Yes, give me a second. I can tell you that.
I see his name in my head, but I just can't recall it. If you can do that, because I thought we were just talking about one. So that didn't have, that one in mind.
Ronnie Long.
Ronnie Long. Okay. Thank you.
Ms. Alexander, please proceed. You may address the committee.
Okay. I am a graduated paralegal from Central Carolina Community College. I graduated in 2018, and basically I have been freelancing as a paralegal, not to cause a harm, because I feel like the cases that have gone before the court and have been, presided over and, judgment ruled, I could have done no harm in what I've done. I just feel like that the complaint that has gone out may have some validity to what I was saying that somebody may not have liked, but any relief that could have been granted to these prisoners, they deserve it. That's part of their constitutional right. Also, too, and I had a really long speech out, and I would like to share some of the points that I had in mind, because when a proceeding is taking place, there are 4 things that should be done by the prosecution and by a public defender, private attorney, or anybody. And that is an ethical conduct. And everybody knows what an ethical conduct is. But, in doing that, some people break the law. And in my case particular, State v. Tammy Alexander from 2010 to 2014, a law was broken against me. And they had the right to correct it, but did not. 2, they had candor. Candor is an open and honesty between the court and the people that's representing or prosecuting. That was not done in my case. That was not done in State v. Tamar Glover. That was not done. I mean, that judge had every right to change that decision before the statute of limitation. 3, too many times they hide behind prosecution, hide behind immunity. Immunity is not a defense. I mean, if anybody deserves a defense from an over sentence or whatever, then they need a proper defense, and they deserve that. And that could go with Tammy Alexander versus State of North Carolina. I mean, I have many against the Chatham County. And the 4th one is morals. I mean, the right and wrong of any decision by the court itself. If the truth is what the court is looking for, then that's what this court should be looking for. Imprisonment should not happen, falsely. So that's all I have to say. And I can say this: the law, I love this quote, the law is an imperfect profession in which success can rarely be achieved without some sacrifice of principle. So if the law was made for one thing alone, for the exploitation of those who don't understand it, then I assume this is why we're here having this meeting today, because I feel like people deserve a proper defense. And if I could have done it in my paralegal skills, I don't feel like a harm was caused. So that's my position.
Thank you, Ms. Alexander. David, you want to respond to that before I open it up to the committee for questions and discussions?
Not sure exactly what I'm supposed to respond to. It doesn't matter what her vision of the philosophy of the law is. The fact of the matter is, she is a paralegal. She is not an attorney. She is not authorized to represent others in their legal interests before any tribunal or any body.
If these individuals had a right to do it per se, they could have taken the same information and done it per se themselves. I mean, they are educated individuals in that prison system. So if I gave them information that could have benefited them, and it changed the scenario or changed the narrative or changed the decision that could have been reversed, then why not?
Thank you, Ms. Alexander. Do any of the other committee members have any questions for Ms. Alexander?
I've got a question, Kevin, if I may.
Yeah, please, Walter, go ahead.
Ms. Alexander, do you
Yes.
understand that what you're doing is engaging in the practice of law without a license?
I do understand that, sir. And I feel like the ones that have brought claims against me have done the same thing. And that's why I brought up the points I made, the ethical conduct, the candor, the immunity, and the morals. If any of that exists in the law, then you know what? I should have never been suffering a harm that I suffered in 2010 through 2014 and the harm that I'm suffering now.
Okay. And do you intend to continue doing what you are currently doing unless the court stops you from doing that?
I intend to be a paralegal because there are so many injustices going on right now. And that's why I got my degree.
So you intend, unless a court stops you from doing it, to continue what is reflected in these materials that are before us?
I intend to work within the law. And if that requires me to work under an attorney, then that's what I will do. I have called these people prior to sending any information on their behalf to assure them that, there's nothing going on. So I've talked to the attorney at one point in time, or talked to, I think, several attorneys. I know I've talked to one for, I can't remember. Melvin Lucky, I think, or Lucky. Yeah, I have. So I have reached out to these attorneys that's representing these individuals and to see if they're doing anything on their behalf and give them my advice. So, I don't know what else to do. If they choose not to help these people, then I can't let them sit there and rot in jail at an injustice.
Thank you, Ms. Alexander.
Okay. Thank you, ma'am.
Ray, did you have a question or comment?
I'd like to commend Ms. Alexander on her enthusiasm and her quest for justice upon these folks, and highly recommend that she apply to law school and get a law license so she could do this legally.
Okay.
Thank you.
Any other questions for Ms. Alexander? And Ms. Alexander, let me just, to try to bring this issue to a resolution, at least in terms of what we have to vote on today. This committee has to decide whether or not to file a lawsuit to seek injunctive relief to prevent you from doing what you are alleged to have been doing. And in the absence of a commitment or representation from you that you you will not engage in this conduct any further, that will probably inform the ultimate motion, consideration, and vote today, which I think is why Mr. Brock was trying to discern from you whether your representations are that you will cease this conduct or whether you anticipate continuing in this conduct.
Or you want a response from me?
Yes.
I feel like that's what I earned my paralegal degree for. And again, I want to work within the bounds of the law, but the law is clearly violating me also. So
Okay.
if my paralegal degree was done in vain, I don't want it to be done in vain, because again, there's injustices that's happening, especially to me, especially these people that I have helped, and no one seemed to want to do anything about it. This man has stayed 40 years in jail, over 40 years, and nobody seemed to do anything about it. Mark Easterling got an 83-year sentence, and nobody seemed to want to do anything about it. And I'm not sure who Judge Bragg, whether I sent Judge Bragg or who that person is, but it's many more. You got Willard Martin. You got, so many more. And the court seemed to turn their head over. And here I am still suffering from the court's ethical conduct, their candor, the immunity, the moral behavior that hasn't changed within the court.
Thank
we
you,
call it doing our job.
Thank you, Ms. Alexander. At this point, the chair would entertain a motion.
I'll move to accept the recommendation of staff council.
And well, to be clear, Andrea, I think the recommendation was to enter into a full discussion to determine whether or not the state bar should seek an injunction against Ms. Alexander.
I was going off of the recommendation in our in our notes, it just says recommendation to seek an injunction. I don't, personally, I don't feel like we need a discussion. I've heard enough, and I am willing to make that motion now that we just go ahead and seek an injunction.
Okay.
Second.
All right. Any further discussion? All those in favor, please vote by, again, click on the participant tab at the bottom and vote by clicking yes or no.
Kevin, that's a unanimous vote of yes.
Okay. Ms. Alexander, thank you for your time. Thank you for being with us this afternoon. And I think now Mr. Oaten is going to remove you from the room so we can take up our next case. All right, let me find my notes here. Thank you, everybody. Let's move on to the full discussion of Mr. Fuller, and I'll turn it over to David for that too.
Josh was handling that matter, so I'll let Josh.
Excuse me. Thank you, Josh.
No problem, Kevin. Thank you. Mr. Fuller has been using the title Esquire with his name, and some judges have informed us of it quite a while ago. Mr. Fuller's response includes some things that are not important, like his picture superimposed on the front of Super Lawyers magazine. It also comes, I guess, with two claims. One, that he can use the term Esquire because he graduated from Oxford, and two, that he can use it because he's a landowning gentleman in the United Kingdom. I researched those claims and did not find them to be accurate. You cannot use Esquire just because you've graduated from Oxford, and they got rid of hereditary titles a while ago for just owning land there. So neither of those are accurate. We do have good case law in North Carolina, actually a case that I handled before the DHC and then David handled before the Court of Appeals, that states very clearly that using the term Esquire after your name implies that you're able to practice law. So I recommend a letter of caution. Mr. Fuller said for a long time that he was going to create a video to show us today, and then decided not to, but just sent another letter reiterating the claims he's already made. I believe David sent that to you all just a couple days ago. I'd be happy to answer any questions.
If anybody has not seen the letter, I'll be happy to share it on the screen.
All right. Tom Anglem has a question.
Yeah, I was looking at the materials and in the federal complaint that he actually listed on page 37 of the documentation. He actually used the scribd.com service. And if you go there and actually put that into your address bar, it lists a lot of the documents he's cited or filed in the federal lawsuit and the state courts as well. Yeah, he files some of these with this pro per reference, being basically a person who appears before the court without legal representation or a lawyer. But then he signs the civil cover sheet for the federal lawsuits that he's filed as an attorney. So I mean, and then in other areas of this data that is available, he refers to himself in that sense, but then at times he doesn't put Esquire behind his name. So it looks like he's cherry picking when he wants to utilize this title for the purposes of enabling maybe a better position of understanding or a better position within whoever's reading this, like he's a lawyer. Yeah, so I understand, having read the stuff before the prior meeting and this meeting, some of it, some of the same information, but clearly this guy is referring to himself and holding himself out to be something that he is not. And I know it would be a horrendously difficult cross-examination for any prosecutor to handle, considering how smart he thinks he is of himself. But I think there's, and I understand the recommendation is, and I'm not just necessarily disagreeing with the recommendation, but this isn't going to be the last time we hear from this guy. And the question is, are we in a position to get that injunction and have it enforceable, or are we going to wait until we have more concrete evidence, or sufficiently enough to put him in a box, so to speak, to prevent him from referring to himself in this manner?
Yeah, Tom, and that's a really good point, and everything you just said is consistent with our investigation and the materials. Two things regarding seeking an injunction at this stage. I would like one of two things before going that route, and one is client harm. I'd like to be able to point to some citizen and say this person has been harmed by this unauthorized practice law. We don't have that here. I'm not saying it doesn't exist. We just don't have evidence of that. Or two, the committee has told him that this is a problem and he has continued to do it. And so that would really be the purpose of the letter of caution, is to get that, so we could say to him, hey, this is a problem, stop doing it. And then if he continues, we can bring it back before everyone and take that next step.
And I guess I'm fortunate that he's not found his way to Beaufort County yet, or my prosecutorial district. But what about Orange County and Alamance County and these other? I mean, is he still, from my perspective, thwarting the administration of justice in those counties by his conduct?
It's certainly possible. And he lives in Wilmington, apparently, sometimes. And so he's under the jurisdiction of my former boss, the DA in Wilmington, Ben David. And I'd be happy just to call down there and see if Ben is aware of this. It's kind of an informal referral, and just say, hey, have you heard of this guy? It looks like he's engaged in UPL. What do you think?
Yeah. And I don't disagree with your assessment as far as going forward, what puts us in a better position going forward if he continues to do what he's doing. That's why I say I don't necessarily disagree with your assessment, having kind of thought that through, as you've said. I can't imagine the level of frustration that this guy wreaks or wroughts upon individuals he's suing, things of that nature.
Well, I expect him to sue me, but he won't be the first one. I'm sure he won't be the last.
Okay, thank you.
And
Thanks,
Kevin,
Tom.
Mr. Chair, I do see a few hands up. I'll defer to you to recognize them.
I see him. Thank you. I think I'll call on President Willoughby first, and then I'll come back to Walter.
Has Mr. Fuller been before the Authorized Practice Committee before, and have we sent him other correspondence about his conduct?
This file has been a long time coming. That's probably when you remember it, Colin, is when you were chair of the Authorized Practice Committee. Alan Hicks dealt with him as well. We've never actually considered his file, because every time we got close, he would make an ADA claim and demand various accommodations under the ADA. And so we had to investigate those. And finally, we came to an agreement that he would make this video and send it to us. And then he didn't. He just sent us this letter. But this is the first meeting since we have been able to resolve all of his requests for accommodations. That's all.
That's fine. Thanks. That answers.
Okay, Walter.
Yeah, that was my question. I remembered this fella. I just couldn't put it in context.
Okay. Anybody else? Any other hands that I'm missing? Okay. At this point in time, the chair would entertain a motion if there are no other comments or questions.
I'll move that that we issue a letter of caution.
Okay. Is there a second?
Seconded.
Second.
Second.
Any further discussion? All those in favor, please indicate by clicking the participant tab and voting yes, and any opposed, click no.
Kevin, that passes. It's unanimous.
All right, thank you.
And Kevin, if I may just very, very quickly, this is my final authorized practice meeting. And I just wanted to say thank you to everybody, especially David, for teaching me how to do this and putting up with me. Appreciate it.
Josh, on behalf of the committee and the entire council, thank you for all your hard work. let's
Don't
move
be too
on.
hasty, Josh. You may come back. You never know.
Let's move on to the consent agenda. I have 3 matters that I am going to pull either on my own volition or because someone else has reached out to me ahead of time, and because there's one person who is with us in the waiting room, and that's number 8, Cox, number 9, Sipe, and number 16, Rubin, R-U-B-I-N. Would the committee like to pull any other matters from the consent agenda? If not, at this point, I would entertain a motion to approve the balance of the consent agenda consistent with staff recommendations, with the notation that Mr. Smith is recusing himself from number 19, Irving.
So moved.
Is there a second? All those in favor say aye, or click the participant tab and click yes. Sorry, I was doing so good. And any opposed, click no. All right. All right, with that, I am going to turn to number, again, because she's in the waiting room, I'd like to take this out of order. We'll go to number 16, Ms. Rubin.
All right, I'm admitting her now, Kevin.
Thank you.
Ms. Rubin, can you hear us? You may need to unmute yourself. Oh. Ms. Rubin, there you go.
Hear me now?
Yes, we can hear you.
Okay, terrific. Thank you.
Okay.
Thank you so much for
Miss-
giving me 5 minutes to.
Ms. Rubin,
Yeah.
let me introduce myself. My
Okay.
name is Kevin Williams, and I am chair of the Authorized Practice Committee of the North Carolina State Bar. And we understand that you wanted to be heard in person today, so we welcome you. What you see on the Zoom screen here consists of the committee, the Authorized Practice
Thank you.
Committee, and other employees of the
so
State
much
Bar.
for, giving-
What I'd first like to do is have let me introduce myself. My name is Kevin Williams, and I am chair. So I'm getting a lot of feedback here. Of the North Carolina State Bar, and
I think somebody has the YouTube stream up.
We welcome you.
Should I turn the YouTube off?
Yes, please.
Please turn the YouTube
Okay.
off.
Or at least
Or you can just mute the YouTube, ma'am.
Okay.
All right, perfect. So first, I'm going to turn this over to staff counsel, either Mr. Johnson or Mr. Walthall. I'm not sure whose file this is, for a brief explanation of this matter, and then we'll give you an opportunity to respond. Okay?
Thank you very much.
Okay, thank you.
Okay, well, Miss Rubin is licensed to practice law in California, but she's not licensed to practice here. And as far as I know, she lives here in North Carolina. I believe at one point she indicated to me that she might be leaving, but as far as I know, she's still here. And she has a website. And on the website, she advertises that she is an attorney. There's no disclaimer on the website that she is not licensed in North Carolina. And also on the website, there's a passage on her one of her pages where she states that she is engaged in preparing legal documents in connection with the cancer clinic at UNC. In her response on that, she indicated that she did it under the supervision of somebody, but it wasn't clear that she did it under the auspices of legal aid. And the only authority under the pro bono rules for an attorney licensed in another state is it has to be done under the supervision of legal aid. And she also advertises as a divorce coach And she states that she offers guidance in collaborative divorces and that she negotiates an agreement between parties in domestic matters. And so the problem is that she's holding herself out as an attorney here, even though she's not licensed here. And there are some indications that she, by necessity, has to be giving legal advice in negotiating agreements between parties in domestic matters. And with that, I'll let Ms. Rubin make her presentation.
Okay, Ms. Rubin.
Thank you. I'd like to thank the committee for giving me 5 minutes to make a presentation. There was a complaint lodged against me by Ms. Turrentine. I was appointed as a court-appointed certified mediator in a case where she was one of the attorneys. During the virtual discussion with the judge and the other attorney and Ms. Turrentine, the judge indicated that he wasn't familiar with the procedure because he'd never had a mediator be replaced, a court-appointed mediator. And I said that that was the same situation for me, that in my 30 years of being a licensed attorney in California, I had never been replaced as a mediator or a settlement conference judge or person hearing a settlement matter, and that I also had never been replaced as a mediator in North Carolina. Ms. Turrentine chose to misstate the words that I stated. I was merely reflecting on what the judge was saying, and I was very clear with my words, as I would be, because I'm very sensitive to this issue. I have a website that is available on mediate.com in California and North Carolina for clients. I'm a licensed attorney in California. I'm a certified mediator, parenting coordinator, GAL, and divorce coach in North Carolina. My website listing at the beginning of the website lists my credentials in North Carolina very, very clearly. It says, I am certified as a mediator, PC, GAL, and divorce coach. There is no certification as a divorce coach. That is a service that I've offered. I have never been a divorce coach for anyone in North Carolina. There is no reference at all on my website to being licensed in North Carolina as a lawyer. I have a lawyer section to my website because I am licensed in California and because this website is listed on mediate.com, which is available to clients in California and in North Carolina. I have only listed services as a mediator, a PC, a GAL, and divorce coach on my website. There's absolutely nowhere on that website that says that I provide legal services. My professional degree is from law school is a JD from a California law school. And so it's truthful and honest for me to state that I'm a California licensed attorney. In the practice area of my website, in the mediation section, I say, quote, the mediator does not tell you what to do and has no decision-making authority, end quote. I have a much different role than an attorney, and I'm very aware of the different roles because I was a family law attorney, and I have chosen to become a mediator. I have taken a 40-hour plus course on mediation. I have also taken a 16-hour course in North Carolina, specifically to get certified. I'm well aware of what a mediator can and can't do, and I have never, ever crossed the line. In my divorce coach section of the website, it says that a coach can, quote, help with finding the right professionals, including choosing an attorney, end quote. I'm very clear about what my role is. I'm very clear that I'm not acting as an attorney in North Carolina. Divorce coach is not a substitute. Divorce, I say in my website, divorce coach is, quote, not a substitute for an attorney. I say, quote, I help a client to work alongside their attorney. I have done certified mediation work in North Carolina, and I have done work as a certified parenting coordinator. I have to be an attorney licensed in another state in order to be a certified PC in North Carolina. PCs provide reports to the parties and their attorneys. PCs are not telling the clients what to do. PCs are trying to help the clients to reach an agreement. On my client intake form for mediation clients, I ask for, quote, the name of your attorney. I'm not indicating I'm going to be their attorney. I have been certified under a pro bono practice order, which was entered under legal aid, allowing me to provide legal services to indigent persons on a pro bono basis under supervision by a legal aid attorney. I put this in my letter. I attached this documentation. I do not know why anyone would say that I have not clearly stated that I was working under the auspices of legal aid. My supervisor was Joseph Lazure. If anyone wants to contact him, please go ahead and do so. I have not provided legal services nor prepared legal documents for members of the public in North Carolina. I have not engaged in the practice of law in North Carolina, nor advertised legal services. Mediation is not the practice of law. It is a process in which an impartial person, the mediator, assists parties in reaching an agreement. Parties are not represented by the mediator during the mediation. The mediator may discuss legal issues, but discussions do not create attorney-client relationship. I am not giving legal advice. I am not trying to get the people to agree to the position that I want them to take. I'm trying to get the clients to reach an agreement between themselves. I draft memorandum of understanding, which summarizes the agreements of the parties, but then, and I clearly spell this out to my clients, it needs to be reviewed by their individual attorneys, and those attorneys need to file the document of the MOU and the court papers, get the client's signatures to become a court order. I do not provide that service. I cannot provide that service in North Carolina. I do not offer to represent clients as an attorney on my website, despite the fact that I can do so in California. I am focused on providing mediation, parenting coordination, GAL, and divorce coach services. I request this complaint be dismissed, and I thank all of you very, very much for providing this wonderful service to the community and to the public. Thank you so much.
Ms. Rubin, thank you. Any questions or comments for Ms. Rubin? Let's see, Mr. Brock.
Ms. Rubin, are you open to clarifying your website materials to make it clear that you are not offering services and are not licensed to practice law in North Carolina?
I would be happy to do that, sir, but I am not offering any services that require you to be a North Carolina attorney on my website. Mediation does not require, I've done what you need to do to be a North Carolina.
Ma'am, my question's pretty straightforward. Are you open to clarifying the materials that are out to the public in North Carolina to disclaim being a licensed North Carolina attorney and disclaim that you're offering legal services in North Carolina?
Yes, I am willing to do that. That's not a problem.
Thank you.
Okay. Tom? Tom, you muted. Yeah, okay.
That was kind of my question too. Looking at her website, you know, if you go across the banner, it has her name, and then it gets home, attorney, practice areas, and that sounds a lot like a law firm. You know, what your practice areas are as an attorney. And I think just looking at it, my first glance, if I didn't deeper into it would be that this is an attorney's website. Even though it says mediation right there, you're still very drawn to the fact that right next to home is attorney and practice areas. And I think if, we can figure out some way to fix that, I'm okay with it.
Yeah, I have no problem putting that in the attorney section, that I am not a North Carolina licensed attorney. Would that satisfy the committee? Just that statement?
We'll see in a minute.
Okay, thank you.
Andrea.
Hi, I am a domestic attorney as well, and I guess the concern I have is this concept of a divorce coach. Can you give us a little more background? Because to me, it sounds like what we would consider an initial consultation where you're listening to their story and giving them recommendations, identifying issues. And I have concerns that overlaps with drawing on your legal experience to make recommendations that fall under giving legal advice. So if you could help me and the committee in describing a little more about what you do as a divorce coach, that would be helpful.
Thank you. Well, first of all, I haven't done that in North Carolina. It seemed a natural extension of my background in services based on my previous career as a family law litigator, that I would be able to do that and that I would be able to help with that. I was thinking of doing that within the confines of a collaborative law situation. And so I wouldn't do it individually without being part of the collaborative law process.
But isn't the collaborative law process by its nature run and directed by attorneys? I mean,
yes, it is. And then there's all different experts that help. Like there's a financial expert, there's a divorce coach expert. In California, it's used more extensively and broadly. And so there's all these different experts. So I was anticipating that if I was part of that process, then I would be one of the experts used to work collaboratively with the attorney that's representing the client to assist with helping the client to understand the vision that the attorney has in the representation. So not to guide the process, but to be a facilitator.
So still, I have to admit, like, I guess I get concerned with I mentioned the divorce coach, but the representation that you're going to participate in the collaborative law process, because to me, it feels like, how can you do that without giving them legal advice?
Well, to try to help them to understand what it is that the lawyer thinks is the right direction to go to. Their divorce attorney thinks is the right direction to go in.
But that's the role of the attorney. I mean, the role of us as attorneys is to make sure our clients understand the law, how their facts fit into the law, and what their options are. So anyway, I just have to let you know that it feels a little bit too close, if not overlapping, with the practice of law when you put yourself in a situation where you're calling yourself a divorce coach or somebody that's participating in collaborative law, which is by its nature something that attorneys control.
Correct. Yeah.
So that's where I have issues.
And I have no problem adding a line that says these services are not offered in North Carolina. Would that suffice?
That would make me feel more comfortable. Yes, I mean, I can't speak for the rest of the committee, but that would make me feel more comfortable. And I appreciate your answers.
Yeah.
Dorothy.
So, Ms. Rubin, my question is kind of piggybacking off of Walter and Andrea in regards to, first, when you were asked about whether you would be willing to update your website to include this language to clarify for both of these different things. And you said yes, which I appreciate. But my question is a little more direct, which is, even though you're willing to update your website, do you genuinely understand the issue with the website as it is and without those updates?
Yes.
Okay. Thank you.
Thank you.
Any other questions, comments? Okay, what's the pleasure of the group?
This is Warren. I move to dismiss.
Is there a second?
Yeah, I'll second that. I mean, I think implicit in that is, I think that we're looking for Ms. Rubin to make the changes that we discussed on the website, specifically making it clear you're not licensed in North Carolina and that you're not doing divorce coaching here. But I think with that understanding and taking you at your word that you'll do those, I would second the motion to dismiss.
Agreed. I'm sorry. I meant, I should have said that.
I was implicit, Warren. I just wanted
Thank you for
to be
cleaning
clear,
up
and I
for
want
me.
you to understand, Ms. Rubin, kind of the circumstances in which at least I would support a motion to dismiss.
Okay, so we got a motion and a second, and I see Gordon Brown has his hand raised. Gordon?
Yeah, Kevin, I would like to make it not implicit, but express that it would be a condition of dismissal. And then have staff review what changes are made and then dismiss if those conditions are satisfied. I understand implicit, and I don't doubt the credibility and straightforwardness and good faith of Ms. Rubin, but I think so we have a better idea of what exactly does happen, we ought to stay involved to that point. That's all I have to say.
Warren, you willing to accept that as a friendly amendment to your motion that the dismissal would be contingent on the actual changes being made?
As long as that is legally proper and as long as Mark Henriquez agrees, since he's the one that brought this up and noticed it, but yes.
I'm fine with that too. Let me ask Mr. Johnson, is that good with you, David, in terms of that process, that you'll confirm the changes are made?
Confirm the changes are made. If it's dismissed, it's dismissed, but we can always, our normal letters always say that we remain free to bring the topic back up if we find something in the future.
Okay,
great.
I see a few hands still raised. Dorothy?
I understand the reason for including that language in there, but kind of speaking to what David was speaking about, is there a certain time frame in which we're going to require her to get this done and have it? I mean, because I foresee that it's definitely a possibility. I think that she's being very forthright here today, and I don't think that she will do this, but it's a possibility that she can make those changes and then very well soon thereafter have the website right back at it. And I wouldn't want to put the onus on our legal counsel to have to constantly monitor this website for some certain amount of time or something like that. I do understand the request for it though.
Okay, Ray?
Can I speak here a minute?
Sure.
Okay. I'm not so adept at websites that I can go and do it today. I wish I was. I can request that mediate.com. Well, what I will do today is I will ask mediate.com, which is where the website is listed, to make that modification. If they can do that today, it will be done today. If they can't do that today, then I need to discuss it with my webmaster, who's my youngest son, and he's in his last semester of senior year, and he's got midterms, etc. So mom kind of has to wait until he comes home on November 20th to get his assistance. Those are the two things that I will do right away. I want to move forward with this. I've had lots of sleepless nights. I worked really hard to be a good mediator, to be a good attorney. In the days that I was an attorney, I made a decision not to be an attorney when I moved to North Carolina 10 years ago. I do not have malpractice insurance. I am not acting as an attorney. I will not do anything that requires me to be in the role of an attorney. And I am super duper clear about that. So I hope the committee will be able to trust a licensed attorney from another state when she says she is not looking to actively engage with anybody in the role of an attorney, or in this case, in the role of a divorce coach, which I haven't been able to do yet, but I will not, I promise you, do that in North Carolina. So again, I'm mentioning that I will contact mediate.com today. I will confirm, I will ask them if it's possible to modify my website in the 2 ways to state that I am not a licensed North Carolina attorney and that divorce coach services are not offered in North Carolina. I will ask them to make that amendment if they can. It'll be done today. If they can't, then I have to wait for my son to come home, which I apologize about.
Okay, thank you. Several hands up. Let me go first to Bobby Bowers. We hadn't heard from you today.
Everyone, would it not be simpler just to continue this to January?
I would really appreciate getting it done. I believe that Miss Turton had a vendetta against me from the minute that she started to interact with me. I do not know why, but the other attorney didn't seem as geared up to replace me, and I was a court-appointed mediator. I'm a court-appointed mediator in 100 counties in North Carolina. And from the minute we had interaction, there was some kind of something going on. I don't know what it was. I didn't contribute to it. And when this complaint was filed, I knew that it was filed by her. And I did absolutely nothing to warrant this complaint. I'm happy to make those adjustments, but I would really appreciate some professional courtesy on the behalf of the committee so that all of us can move on and that there be trust of a person who's certified as a mediator, PC, GAL in the state of North Carolina, has done pro bono service for legal aid for the last 4 years, preparing power of attorney forms for cancer patients at UNC Chapel Hill and immigration clinics. I've done nothing to warrant this kind of action against me. And frankly, it's really insulting and very, very unpleasant, as I'm sure each and every one of you can understand, being licensed attorneys.
Okay, still got some hands up. Ray?
I share Bobby's concern that we ought to postpone this till January. And my reasoning is, I think it's going to take more than just a disclaimer word in there. When I look at that website, there's an intermingling of all of their experience as a practicing family law attorney. And as you read it, you don't really, you'd have to look back to see that you're talking about California. And to the typical consumer, I don't think they're astute enough that they would do that. I think they are being invited into reading all about her qualifications and all the work she's done in custody and litigation. I think there's a lot of language in there that to me is misleading. And I think it would take more than just a simple disclaimer note to rectify that.
Tom?
And I guess I'm concerned, in addition to what Ray said, should we be setting this type of precedent with a conditional dismissal from a procedural perspective under these circumstances? Yeah, and I guess maybe one remedy would be to table the motion. And then when we come back, the real question is, we get a report that this is how the website has been changed. And then we just vote on the motion to dismiss as it's proposed and has been seconded at this at this moment. So, and again, I've only been on this committee since January, so I don't know if there's a historical precedent for conditionally dismissing these matters. And again, I'm not saying anything about your credibility, Ms. Rubin. I believe you. Okay, I'm just looking at it from a procedural aspect and trying to make sure we kind of focus in on the things Ray has mentioned and others have mentioned, that and Andre as well, regarding the concerns that we have.
Thanks, Tom. Warren Savage.
So now I'm not clear.
Hang
Hold on a
on.
sec. I'd like to go ahead and have a vote on my motion, and if it's defeated, so be it. But I'd like to give Miss Rubin some finality if she can get it today.
And again, Warren, clarify what you contend your motion is, just so everybody knows what we're talking about.
Can I hand that off to Mark?
Yeah.
Yes. The motion to dismiss, and I think to address your point, Tom, I mean, my concern is it's not clear to me she's offering to provide any legal services in North Carolina. So that's why I think a dismissal is appropriate. I do think you could look at the website in a way that it may be confusing. And she talks about being an attorney without explicitly saying she's not licensed in North Carolina, but I understand she's saying she will remedy that. I think we can dismiss it. If she doesn't do that, I expect to see her back again next quarter with a continued concern. But I think the motion is to dismiss with the understanding she'll make 2 changes to the website. One is under the attorney tab to expressly state she's not licensed in North Carolina. The other is in the practice area to expressly indicate she is not serving as a divorce coach in North Carolina. I think that's the motion. And yet again, people may not wish to vote for it, but I think that's the appropriate course of conduct at this stage. So that's, as I understand the motion, I seconded is that motion.
Yes,
All right.
that's my motion.
Okay, and I'm gonna try to land this plane quickly. Gordon, I'll let you speak briefly.
I think Mark has summarized the point I was trying to make. I think being clear about it is better for all concerned. And
Dorothy?
I'm prepared to vote. I'm prepared to vote.
All right, thanks, Gordon. Dorothy?
That was from before. I'm sorry. I didn't realize my hand was still up.
It's okay. Ray, did you need to be heard?
Do not.
All right, and I saw one other hand.
Andrea.
I'm sorry, I know you want to vote, but I just have a recommendation. I mean, I'm supportive of the motion, but a recommendation to Ms. Rubin that perhaps when you are working on your website, you can have it divided between what services you offer in California and what services you are offering in North Carolina. And that might help clarify, what you can and can't do in each state.
Okay. And I know I don't see any other hands raised. I did see Mike Ramos's hand up earlier, and I think Julie as well. Do either of you need to be heard?
I got my question answered. Thank you.
Okay, thanks, Julie. Mike? All right, seeing no other hands, all those in favor of the motion, please vote yes by clicking the participants tab and voting yes. And all those opposed to the motion, please indicate by clicking no.
The motion passes 21-8.
Motion passes 21-8. Okay, thank you. And Ms. Rubin, thank you very much for being with us today.
All right, and so my understanding is that the complaint was dismissed and that I need to make these changes to my website.
Yes, ma'am.
And will I get a formal letter saying that?
Yes, ma'am.
All right, thank you so much.
You're very welcome. Thank you.
Thank you. Have a good day. Bye-bye.
Yep. All right. Two additional matters to attend to from the consent agenda. Number 8, Cox. Mark Enriquez asks that one to be pulled. Mark, do you want to?
Yes, sure. just as a reminder, folks, this is the one where Mr. Cox called the attorney for Pikeville because a friend of his daughter's had a dispute with them, and she asked if she could help find out what was going on in connection with her job status. And basically, the attorney for Pikeville said, "Are you an attorney?" Mr. Cox said no, and then he said, "Well, if you're not an attorney, I'm not going to talk to you." I don't think that's an unauthorized practice of law. Mr. Cox never indicated that he was an attorney. And I don't think this is necessarily something that you have to be an attorney to do. We don't have a lot of facts about what the underlying dispute was. I don't think it's enough, though, that the town attorney thinks this is a legal matter that he only would talk to a lawyer. I think this is someone who was an EO counselor who's trying to work out potentially a non-legal resolution. And I think we really stretch our authority too thin if we're saying anytime you call, a government official, to raise a concern about something, you need to worry about whether you're practicing law. And so I think a dismissal is the appropriate course for Mr. Cox.
Okay, I'll construe that as a motion to dismiss.
And
Is there a
therefore I
second?
move to dismiss. Yes, thanks, Kevin.
Is there a second?
Second.
All right, and I know I saw a hand up. Brandy, did I see your hand up?
Yeah, I wanted to notice everyone I have a conflict with this and not participate. I'm sorry for being late.
Okay, we will note that in the vote on this, Mr. Vickery is recusing himself. So there's a motion. We have a second. Any further discussion? Then it's a motion for a straight dismissal. All those
Gordon
in favor,
has his hand up.
I'm sorry, Gordon Brown, go ahead.
Yeah, and I just want to mention quickly, I think last quarter we had a case very similar to this where a man in Charlotte interceded on behalf of his niece with the school board. And I think we dismissed that one, if I'm not mistaken.
I think that's right.
Okay.
He was a lawyer.
Okay. We got a motion and a second. Brandy, it's still showing your hands raised. I'm just going to, it went away. So all those in favor of the motion, please indicate by clicking the participants tab and voting yes. And if you're opposed to the motion, please vote no. Looks like that passes unanimously. Am I right about that, Brian?
Yes, that's correct.
All right. And the last one from the consent agenda that I wanted to pull is number 9. And this is Billy Sipe. And the only reason I pulled it was because I thought if we voted on it as part of the consent agenda, it just wasn't real clear because the recommendation in the body of the report of counsel says that the council recommends either a letter of caution with no probable cause or a dismissal with cautionary language. And I just thought we just needed to give David some direction as to what we want to do, since it wasn't clear what the recommendation was.
And
David,
Kevin,
yeah.
This is Mark. I would move for it to be a dismissal with cautionary language. Again, we don't have any evidence that this contractor was actually going to be trying to negotiate liability. And so I think a cautionary language is saying, yes, you can do this work, but you can't be a lawyer. You can't be raising liability concerns is probably sufficient. So
that's the motion. I second it.
All right, so we got a motion, we got a second from Bill, and Ray Bretzman has his hand raised.
Well, the only thing I would add to that is that body shop workers and staff do this every day. They contact insurance companies and they literally negotiate the work that's being done, not whether or not there's liability as such. So I think this is being done regularly as an ordinary custom of business and throughout the economy.
Okay. We got a motion, we got a second. Any further questions or discussion or comments? Please vote by clicking on the participants tab, voting yes or no. And again, we're voting on a dismissal with cautionary language. It looks like that passes unanimously. And according to my notes, that takes care of our entire agenda. unless I am missing something someone wants to bring to my attention. All right, anything else to come before the committee today? If not, thank you all very much for your time. We went slightly over the hour, but I thought we did some good work today. So thanks everybody, and look forward to seeing you throughout the week.
Kevin, just real quick for all the members that are still on the call, if you are on the issues committee, issues is starting at 2:45. You can find the Zoom link